Informative for more about over daily updates. So, Ebusia, you discuss breaking update we and Sabeka. Your mind mo a trademark bia and yes it will be an am so bad a Ghana mrani mu say obi petition the president efa obi ho a also consulted the Council of State no mo hwe ensem assuming like maybe a year state officers like Mensa Torkono Charlotte was saying into no ohwema petition was say a for process so na omutimi establishing prima facie na just say ensem no mo ko mo no ensem bi wo ma etia wo dia na just say we see you film na ni na say maami Torkono na enipa mensa a petition mama say maami we ye pese wo yini free office say ni so enti yini free ho ana odi nsem na koda eye Council of State but minority one Afenyo Markins odi animu ene amunya or call it the Ghana bar or call it the stakeholders or call it I don't understand because a process I am right and we usually obi na feel so we ni free and I say there be because to Georgina would be a chief just obi you know it is all retire ain't no sir the abetos no script no and that's political hazard you say leaked petition. Chief Justice is Chief Justice in communication with minority caucus. Ni nyina ne say eduju tamakuru ene bisa wasi eye maami Torkono ene my Afenyo markets omunya nkuta ho bedie because the leaking information leaking say omu ko hye baabi na omu di nkomo na omu ye den enti wo hwa Afenyo of late obo pressure say stakeholders eye hwan omu mu amaye Chief Justice ene eduju tamakuru ebisa because our information ni evidence be a leak and I say any may be a water no osusu say minority no ene eye Afenyo Markins ene eye minority ni nyina ene maami Torkono eden enya nkutahudie bi ase omunya kokuo mu nkomo bi omunya kokuo mu nkomo ebusua ene da so ngo tie lawyer edit tamakuru ensema na okanti lawyer edit tamakuru ene busa ene da script no ene da so no we say eye edit tamakuru act because ultimate information edit tamakuru kitano eno ntina oman busa we ene so na hwe na subscribe. God bless you. Stay tuned.
We've actually seen that that's been our history that is shown that some judges are not able to hold their independence. Okay, yes, once they get their appointment, then they seem to pander. Others have held it well, but look, if we are speaking bluntly, overall, we all know that generally the judges would, seem to defer to the presidents that appoint them. That's the overall picture. We are not saying that 100% that's what happens, but we mean generally. And Professor Tuguba once did a paper on it, and when he released it in Gimpa some years ago, it brought the judiciary to their feet. I remember Chief Justice Sophie Kufu then, Yasantua, our beloved Yasantua, telling Professor Atuguba to, be more nuanced, to put, salt, the fruit. Okay, no, that's not. But we're just saying that it's a human problem. And so far, we have shown that we are about to take the lead. We are about to make sure that the president doesn't appoint superior court justices and doesn't appoint the Chief Justice. Sophie Kufu said it. She granted an interview. Before she granted it, we even had started. This is a conversation that has been going on. It's been over 10 years since this conversation started that in the new constitution, the president should not be appointing chief justices. We need a different judicial council that would not also have many of the president's appointees. The president will not appoint persons onto the judicial council. It will be independent. And it's that judicial council that will see to the appointment. So yes, we are moving towards there. It looks like JM is ready to give it. Everybody sees that JM is hungry to leave a legacy. It looks like he's hungrier than Kwame Nkrumah, it appears, because he wants to leave his mark on this country. And it's good. It's good we trolled him in opposition for 8 years. I think the trolling has finally, it got to him. And so that the next time I get an opportunity to lead Ghana, I'll be said that even Kwame Nkrumah will find it difficult to beat me. And so far, it looks like it. So even though we've not yet seen the work of the Constitutional Review Committee, it's very clear that generally the nation is moving towards an independent judiciary, at least in the form of appointment. Let's not forget, even when the president doesn't appoint the justices, there are other ways the president can control. You remember Chief Justice Torkono, the current Chief Justice, said it, that at a point, Akufo-Addo was using money to control the judiciary. He would not release their budgetary allocations, and thereby would be able to control them. So we'll still be then left with the financial independence. So perhaps the chairman of the Constitutional Review Commission, Professor Prempeh, should be looking at that angle too. How we'll strengthen it. Yes, currently, on paper, they will tell you that, oh, when the judiciary send their budget, you can't cut it and the rest. But practically, there are ways of going around it. So perhaps the committee should be looking at how they can get the financial independence too.
Actually, now, and this is why I bring Lawyer Digital Maclo, because I just want to run up on this aspect of the conversation, because it ties directly into the current state of affairs. Is there a real challenge that this call for the review of these powers will solve? Council?
I think that we are faced with an issue that we should not confuse matters. What we are discussing this morning relates to a press conference by the minority leader. He calls himself the mighty minority leader. What that means, I don't know. But what is not in doubt is that the minority leader says that there is an unacceptable attempt by the NDC to infiltrate the judiciary, and now says that civil society groups must condemn that act. And not only that, he invites all other persons, religious leaders and what have you, to tell President Mahama to stop what the Constitution says he should do. Article 146 of the 1992 Constitution is in clear terms. Thankfully, our Supreme Court had the opportunity to interpret Article 146 on the removal processes, particularly as it relates to a Chief Justice. Question: has President John Dramani Mahama done anything today not stipulated by the 1992 Constitution? Certainly the answer is no. Now, President Mahama, having assumed the office of President of the Republic of Ghana on the 7th of January 2025, has received 3 petitions. The petitions are to the effect that, based on the constitutional arrangement, the only that you can remove the Chief Justice or a Justice of the Superior Court is 1, through stated misbehavior, incompetence, or infirmity. As I speak to you now, I have not had the benefit of seeing the content of the petition. I have not seen it. Because if you recall, the Supreme Court in Franka J. Chum had provided a certain parameter that the entire process should be kept in camera. Strict confidentiality. So President Mahama, guided by this decision of the Supreme Court, has kept the petition under one of the principal advisors of Nana Addo Dankwa Akufo-Addo on legal matters. Did not advise Akufo-Addo to give Charlotte Osei the benefit of these 7 days or 10 days. That is our record. So it is a mark of, let me say, it is hypocritical for my learned senior Afenyo Markin to do a press conference and suggest that President Mahama is doing something untoward. It's regrettable.
Well, no, he's not the one who holds that. The argument by the immediate past Attorney General is that to the extent that this injunction application is being heard, it behoves on the president to halt any process ongoing under Article 146 until the determination of that case.
You see, as for Godfred, I won't even talk about him for now. Let me deal with a major issue. You see,
that underlines the position that Markin has taken.
President Mahamad's fidelity to the 1992 Constitution is something that should be celebrated. When he became president, he appointed a Shrad boss called Madame Vivian Loretta Lamptey.
Yes.
Now guess something. Honorable Frank Anodompre, NPP MP, and another gentleman by name Richard Nyama brought a petition to President Mahama that the Shrad boss so appointed by him has misconducted herself, financial issues, and therefore we're seeking the removal of the Shrad boss. Yeah. President John Dramani Mahama, consistent with his character to uphold the rule of law, accepted the petition, forwarded it to the CJ then. The CJ then made a prima facie determination, and the Shrad boss, Madame Loretta Lamptey, then
an appointee of President Mahama
was removed by President Mahama.
Yeah.
Consistency.
Yeah.
Today, as we speak, President John Dramani Mahama is in receipt of 3 petitions. I don't know the individuals. What has he done? Having received these 3 petitions, to warrant that unprovoked, meritless provocation from Afenyo Markin. Has President Mahama done anything inconsistent with the 1992 Constitution? No. He received the petition. The Chief Justice said, President, I have become aware through a press release by your spokesperson, the Honorable Felix Kwachi, that these petitions are in your custody for my removal. Mr. President, before you make any comment further on this petition, Mr. President, I want to respond. The President said, well, I mean, that's fair. In fact, you should have actually spoken to me. Meanwhile, the letter requesting for it, you've copied other people. But that's beside the point. Your request is legitimate. I will give you 10 days to adequately prepare. Now, the president, having done this, was it consistent with the Constitution? Due process. He said, look, let everybody, you can't condemn a person without hearing, even though I differ. The president says, I will do that. Now, the Council of State or whoever is supposed to go into the merit or otherwise of it. If the Council of State so advise the president and advise that he is not bound by law, what you do, if he sees that there is a determination of prima facie, you do a 7-member, a 5-member committee comprising 3 justices and 2 quote-unquote civilians to determine whether it merits your removal. In the meantime, the president has the power to suspend you. Now, from the time of the receipt of the petition to date, has President John Dramani Mahama done anything outside the strictures of the Constitution? No. Now, listen carefully.
I just want clarity. I'm told that there had been a ruling that says that if there is a petition against the Chief Justice, the President is not bound to give a copy of that petition.
No, so you see,
I'm just asking.
No, so you see, there were 2 schools of thought.
Okay.
That flowing from the Frank Ajechum decision.
Okay.
There is a lacuna. And that at this point, really, because personally, I think that when a petition comes and you respond copiously, it means that on the face of it, there is something that needs to be looked into. Okay. That's my view. And so I strongly believe that even at this point, the question of giving a copy to the person or respondent here is a bit, the Constitution itself is a bit silent on it.
Okay.
But President Mahama said, regardless,
Okay.
I will give you the opportunity, and gave her 10 days to respond. Now look at this. Afenyo Markin, who addressed the press, one of the principal legal advisors to Nana Addo Dankwa Akufo-Addo until he left office, was here when Madame Charlotte Osei's petition came. Faceless individual. With all the issues, Madame Charlotte said through her lawyers, wrote to Mr. President Nana Addo Dankwa Akufo-Addo for a copy of the petition to respond. Eugene Ahin, the presidential gongon beater, then said, listen carefully, then said, it is not in the place of President Nana Addo Dankwa Akufo-Addo to give Charlotte Osei a copy of the petition. Mahama didn't say so. Mahama said, have it. Madam Sophia Akufo, then Chief Justice, because it relates to, did the prima facie determination. Eventually, the president appointed a 5-member committee. My Lord Justice Benning, the late Justice Mafosa, Agnes Doji, Abrampa, and another woman. They went into the merit and said, look, there is grounds, and recommended the removal of Madame Charlotte Osei. It was a 3-2 majority decision. You understand? So that is our record. Has President Mahama today done anything outside what Akufo-Addo has done? In fact, he had even gone a step higher. The lawyer Akufo-Addo was not willing to give a copy of the petition. The non-lawyer John Dramani Mahama respected the request of her ladyship, the Chief Justice, and offered her. She even requested for 7 days. President Mahama.
Don't compare President Mahama to
Please, gentlemen. Gentlemen,
I
understand you are unconstitutionally interfering in my submission.
But I'm saying, if you compare,
So I am saying that. Wait. So I am saying that this attack from the minority, and I've heard my learned senior Daku and the minority leader, I see that Afenyo Markin cleverly wants to turn the conversation into an NDC NPP thing to muddy the waters. Cleverly. And if you heard my national chairman, he said, this matter, we are not talking about it, the merit or otherwise.
she speak.
President John Dramani Mahama has so far conducted himself so well. And it's also because he had the benefit of sound legal advice with the likes of the Attorney General, Marietta, and co. around him. They would not allow the president, even though a non-lawyer, to do anything outside the constitutional stipulation. And so, you see, I think that regardless of the merits of the petition, and I don't want to go into it, regardless of that, I have seen media houses, some other media houses and colleagues say, oh, the NDC wants to remove Madam, what's her name, Chief Justice Torkono, because either than that, the NDC cannot do oral or something.
And that you don't trust the current architecture of the judiciary to prosecute the oral
Let me
cases.
tell you. Okay. Good. My Lord Justice Akabuafo was appointed by President Mahama High Court. Then Nanado took him to the Court of Appeal. Right? Yeah. Good. So he strained both regimes, correct. I did Ato forcing at the appeal before him as one of the Court of Appeal judges. When he saw merit in it, even though he was appointed by President Nanado to the Court of Appeal, he saw merit in our appeal and acquitted and discharged. So for me, the idea that, oh no, because you have been appointed, in fact, her ladyship Justice Torkono, do you know who took her to the Court of Appeal? Do you know who took her to the High Court? She strained all the political parties So this has nothing to do with whether she was appointed by NPP or NDC. What we all need to do is soberly reflect, and I'm sure if a prima facie determination is made, we'll all have the benefit of knowing. Look, in the case of Charlotte Osei, and remember that when Charlotte Osei matter happened, Frank Ajechum had already been decided. As at the time, Nana Addo Dankwa Akufo-Addo forwarded the Charlotte Osei petition to her ladyship Chief Justice, I think Sofa Akufo, right? And she made a prima facie determination. What was it on? Procurement breaches. I remember at that time, I cautioned. I said, no. Superior Court judges, because of the countervailing force in our democratic experiment, right? The grounds for their removal should be something very serious. At that time, my friends in the NPP, said, no, it matters not. Procurement breaches is enough, and that constitutes stated misbehavior. I said, look, the Procurement Act itself envisaged the possibility of violation and provided in Section 90 the opportunity to rectify. And so, in the wisdom of the maker of the law, they envisaged a situation where there could be mistake. So they said, set up a committee, investigate the matters. If the committee now makes... So I was looking at a situation where before you can remove a judge, it should be on grounds that he has stolen public funds. There's some... Our friends in the NPP said no. And I remember, and I said this with so much sadness. Kweku Baako issued a writ at the Supreme Court. His lawyer was Samson Ladi Ayenene. That day, I happened to be at the Supreme Court with my senior Dr. Ayene on a different matter. That same day, the Charlotte Osei suit came. Kweku Baako's suit came up. His Lordship Justice Nana Megache asked Samson Ladi, Samson, are you saying that a breach of the Procurement Act is not a violation of a law, is not stated misbehavior? And that was it. That day, I left the court sad. I said, look, if we put it in that context, all of us become vulnerable. The level of vulnerability is high. But I think at that time, it was convenient for some people to do that. Possibly because it was Charlotte Osei. And I've always maintained that tomorrow is pregnant. The accounts have been saying, yes, oh, you are for son. Now, why a day? Why should one son? Look, why is Afenyo Markin panicking? Does he have the benefit of the petition and its context?
Well, there's been some references made to some allegations that they, by minority, purport to be in the petition, which they describe in words as frivolous. In fact, the current Swami Member of Parliament, John Darko, addressed the press this week, referencing some allegations purporting to be in the petitions against the Chief Justice, and the description given to those allegations.
So
that
you,
they are
so
frivolous.
you, let's.
I want us to take a listen to.
So that I can come.
John Darko, let's take a listen to John Darko.
Let's listen to
quickly.
John Darko. Then I can.
And then I will set the matters in context. Take a look.
We are told that a gentleman who committed contempt in facie courier and was thus accordingly punished by the courts was the CJ because he has been punished by the court, not the CJ. One of the last allegations we've heard, which is ridiculous, is the fact that the CJ has misappropriated some 75,000 Ghana cedis. An accusation which from the Judicial Service has been dealt with by the Auditor General's outfit. Justice Torkono's distraction should not be the grounds for your rising to the office of Chief Justice. To you, that judge, remember that you can.
In honoring the request, sealed the petition before giving it to her. Who informed the minority of the details? If her ladyship, the Chief Justice, in communication with the minority, because at this point, The petition is between the president and the Chief Justice. And in fact, for the president to guide the integrity of the process, he marked the petition. I've heard one other journalist of Metro refer to what they claim to be the content of the petition. Who leaked to them?
That is, if it the details.
No, but this one he phrases that we are told.
Yes.
Who told
I listened to him carefully.
No, I just played that.
Who told him these contents? But you see, how come that he, John Darko, his own colleague, Afenyo Markin, Frank Anodompre, brought a petition for the removal of Loretta Lamptey. President Mahama didn't say it was an NPP MP against my appointee. He received the petition, actioned it, he found merit, and dismissed his own appointee. How come that today, Anodompre and his minority do not have confidence that President Mahama would do same thing he did to Loretta, affording her the opportunity to defend herself? Where is the fear? Where is the panic? You see, the stand of the minority relative to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146 to perform that role of receiving a petition. It is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me. Only president. The president. Who is the president of Ghana? Possibly the petitioner should have addressed it to the NPP minority
before
and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior John Darko, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Darko, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo-Addo did it. The three commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there is any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No. Charlotte says prima facie determination was made by who?
By her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make, yes, if she could make a prima facie determination for the removal of Charlotte on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Benny. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judicial.
I'm here, I will speak.
Has President Mahama, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. Yeah. No, 2005, even though it reflected 2004. When the Chikata trial, the fast track composition, where in the midst, President Kufuor appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast track decision. The African peer review mechanism report indicted the president as directly interfering in the judicial. President John Dramani Mahama does not have that reckless record. So where is the conversation going?
Okay.
President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Markin and his micro minority, President disobeys the constitutional order, that's grounds for his removal.
Indeed.
At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says.
Right.
Let's see what the coming days will reflect.
Indeed, but lawyer Christian Mamhesi as well on this, because where is the concern really so far in the process as it's unfolding under 146, Article 146? Where exactly does the position by, for instance, the immediate past Attorney General have merit, that to the extent that there is an application for an injunction, the process should be put on hold until the determination of such a case before the process resumes, to hear even the petitions against the Chief Justice and have that consultation with the Council of State? Where does that argument have merit?
Okay, all right. It refers to, there's this case that came before Akabuafo. J. Accident was now at the Court of Appeal, where the case is ex parte Mahama Bugri. And in that, he had to deal with